Steve, this award is given to you by HCDLA, Harris County Democratic Lawyers Association, for your lifelong work in preserving the right to trial by jury. So thank you and continue your good work.
Thank you. Thank you very much. Thank you. Great job. Thank you. Nothing could make me prouder than to receive an award named for our country's most prominent trial lawyer and one of its staunchest defenders of trial by jury. I want to thank Amber Mostyn and my partners at Susman, Godfrey, for being platinum sponsors of this event and for not only walking the walk over to the courthouse for the ceremony, but having opened their checkbooks and written checks as well. I also want to thank the other individuals and firms which were sponsors. For the last 5 years, I have been passionate about two causes: saving the federal judiciary and saving trial by jury. Both, as you well know, are under attack. I have unquestionably been wearing the partisan hat of a Democratic lawyer in my efforts to stimulate the Obama administration to pay attention to filling vacancies on the federal bench, and in my current efforts to prevent the Trump administration from destroying that bench altogether. Destroying it by putting lawyers on the federal bench at the trial court level that cannot spell trial or jury, that are carpetbaggers. They do not hail from the cities where they are appointed to serve on the bench. They rather come from the chambers of Justice Alito, Scalia, and Thomas. As chair of the American Constitution Society's Judicial Nominations Task Force, I had some luck in 2015 with getting Obama to focus on nominating federal judges and in getting Democratic senators on the Judiciary Committee to quickly get them confirmed. In the case of trial court judges and appellate court judges, it was a little, too late. In the case of Scalia's replacement, our loss of control of the Senate meant the Republicans were able to frustrate President Obama's choice of Judge Garland. So my message to you, a group of Democratic lawyers, is blunt. We have an uphill battle winning the Senate this year. But if your resources are limited, you should focus them on the 9 incumbent Democrats, particularly those in red states. Senator Tester, Senator Heitkamp, Senator McCaskill, Senator Manchin, and Senator Donnelly. If we can't win back the Senate this year, what happens in the House is irrelevant, particularly if Justices Ginsburg or Breyer or Kennedy don't hang on until January 2021. That's a long time for these men to hang on. We can survive the current administration and the current House of Representatives and their repeal quickly of necessary regulations of the environment, the economy, and healthcare. We can survive their getting rid of virtually every cause of action known to the law profession, known to trial lawyers for remedying wrongful conduct. And we can survive them federalizing what causes of action remain. But we cannot, and their destruction of federal agencies. because a new Congress under a new president can reverse course immediately. But if there is a single Supreme Court vacancy, we will be stuck with a court that will strike down anything we as Democrats believe in and strike it down for the next 100 years. As a lawyer and a Democrat, you need to consider how this will affect your grandchildren and your profession, because if it happens, it's not going to be pretty. And you need to dig deep and help out. You can max out to all 9 of the endangered Senate Democrats, the incumbents, for $48,600, which I suspect for many of you is a small fraction of your anticipated income from the legal profession over the next 5 years. Now that ends my blatant appeal to party, tribe, and profession, for which you will receive no CLE credit. But let me segue to the subject of juries and jury trials. That, as you know, is a right that is mentioned 5 times in our founding documents. Once in the Declaration of Independence, once in the Constitution, and in 3 of the Bill of Rights. And it was a right, the right to trial by jury, that was guaranteed by the constitutions of all 13 states that ratified those nation-building documents. That right was important to the founders because their chief executive in 1789 and 1791 was a guy named King George, who was not unlike our current leader, an autocrat who thought he was above the law, who demanded the loyalty of judges he appointed, and who had little respect for the rule of law. Those who ratified the Constitution on the condition that a Bill of Rights include preservation of the right to trial by jury were fearful of that our president would someday have those characteristics, and that their fear of overreaching federal power of a central government and of judges who were zealots and ideologues would somehow, they never wanted to face that in this country, and they thought that a trial by jury was the ultimate check and balance on uncontrolled judicial power. When my wife and I established the Civil Jury Project at NYU in 2015, it was not because of these fears. That was pre-Trump. But it was pretty prophetic that we did it then. When we did it, it was because for the last 50 years, I have been trying lawsuits, and I realized that jury trials were disappearing. I could no longer, what really woke me up was we gave, at our law firm, a questionnaire to our associates about 5 years ago on, what do you like about the practice of law? How do you like working at Susman Godfrey? And on one of the open-ended questions, one of the associates, it was anonymous, answered, when are you going to stop lying to new lawyers about your ability to give them trial experience? That was a wake-up call to me, because then I realized that rather than wasting time teaching trial advocacy at some law school in my senior years, which would be a little like teaching dinosaur hunting, I would better be spending my time if I could somehow do something to keep jury trials from becoming extinct. And so we set up this center, the Civil Jury Project, and it is the only center that's asking these 3 questions. Why are jury trials disappearing. And by the way, one of the things I found out, which I did not know when I set up the center, was that bench trials are disappearing faster than jury trials in every federal court and every state court around the country. I never knew that the disappearance was as serious as it is. The average judge in this country, state or federal, tries less than 4 cases to a jury a year. And only 1 case is a bench trial. And the same thing occurs on the criminal side of the docket. So it doesn't matter whether it's civil or criminal, and whether it's bench or jury, we are marginalizing public dispute resolution in this country. It is all being privatized. Private judges paid $750 an hour. Now, we as lawyers have got to, I'm not going to stand by after 50 years of having reaped the benefits of being able to try jury cases and let this happen. So we are asking the question, why are jury trials disappearing? Do we care if they disappear? And a lot of that is historical. You've got to understand why they were so important in this country from the beginning. And finally, what can be done by lawyers like us and judges, many of whom are here today, to stop the trend. I work as the executive director of the Civil Jury Project, and I do go around the country talking to a lot of federal and state judges. We publish a monthly newsletter for judges and academics and lawyers, and we put on jury improvement lunches around the country. We host jury trial workshops for judges. We are the only source, really, and no new judges school, neither the federal new judges school nor the state new judges school. Anywhere are they teaching judges how to try jury cases. It's not a subject anymore. And what we get from judges around the country is, I'd love to try a case, but there are none there to try. Sometimes they say it's because the lawyers, who have principally become discovery lawyers, don't know how to try jury cases anymore. So, it's a bad situation. So we're trying to remedy that situation. Next week, we are inviting what the Republicans and the Federalists did when they decided they needed to get rid of litigation, because every lawsuit was by definition frivolous and abusive, was they figured the way to do this is to go to the judges. The judges had the power, and so, as you know, they began inviting all the federal judges around the country to these weekend retreats at George Mason University, where they taught them conservative dogma, the dogma that the only thing important about the courtroom is getting rid of cases, disposing of them, not fairly deciding them by fair means. And so these judges look forward to the opportunity to go play golf at some resort, and they went and they got indoctrinated. So I'm trying to indoctrinate them back. And we have had we have a seminar room at NYU that holds 30. The Civil Jury Project is inviting these judges, we have 30 state judges coming on Thursday for a full day of talking about jury trials, and 30 federal judges coming on Friday, back to back. And what we find is that when they get around a room and begin talking about it, just talking about it makes it more likely that they are going to try a case than dispose of it on the papers with no hearing at all. And so this is our second time we've had these workshops at NYU, and they are very fruitful because the judges then they experiment with innovations, and they tell us about how they can have more jury trials. We have also put on these jury improvement lunches. This month, We will, in April, we will put on, by the end of April, we will put on 15 around the country. As you know, the first one in the country was held in Houston, Texas, several years ago. We are scheduling a third jury improvement lunch in Houston on May 2nd, and we urge you all to come. It's at the Magnolia Hotel, and that's where we invite federal and state judges to come. We invite them to invite jurors who have been discharged, and the jurors come to these events and tell us about normally how great an experience it was. We have set up by learning what we learned from these judges, we have set up a website called WeThePeopleWeTheJury.com. You should take a look at that. We use social media to encourage people who have received summons to go to this website, and they will, they're looking for ways to get out of jury service, and instead of getting out of jury service, we show them video testimonials for people who have been served on a jury about what a wonderful experience it is, in a hope that we will increase the yield and the interest of people in serving on juries. And it is working. Our traffic on that website has been tremendous. A high priority of our project has been educating judges to how they can help train young trial lawyers, because we don't want them to complain in the future that they can't find anyone who can try cases. When I started practicing law in 1967, Houston was at the epicenter of the American trial bar. Routinely, the largest number of the nation's top-ranked trial lawyers practiced here in Houston. We didn't have Clarence Darrow, but we had giants like Percy Foreman, Joe Jamel, Racehorse Haynes, and Jim Cronzer. Wouldn't it be fitting for Houston to again be the source of the rebirth of trial by jury? With your help, we can make that help happen, and Clarence Darrow would be proud of us all for doing so. Thank you.